Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists and uncertified podcast co-hosts. Each episode, we try to bring our audience of trial and appellate attorneys some legal insights and news they can use in their practice. If you find this podcast helpful, please recommend it to a colleague.
And a quick thank you to our podcast sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse their service. And listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/kelp. That's casetext.com/CALP.
And Jeff, today we're pleased to welcome Kristi Thomas to the show to talk about her recently published article about the legal and ethical traps to avoid when referring a client to another attorney. Kristi Thomas is a labor and employment attorney with Shepherd Mullen. She's also actively involved in the firm's pro bono practice. Kristi's practice involves representing employers in the defense of complaints for class action and single plaintiff matters. Kristi also provides counseling and training to employers on issues like wage and hour, disability and family and medical leave, discipline and termination, and sexual harassment and workplace behavior. Kristi began her legal career in Philadelphia in 2008 before becoming a member of the California Bar in 2011. Kristi, welcome to the podcast.
Thank you guys so much for having me. Very happy to be here.
Yes, terrific to have you. Now, I read a very brief version of your bio. Is there anything that I missed or anything you'd like to talk about to kind of introduce yourself to our audience?
Yeah, the bio does a great job at covering my legal practice and my experience, but it doesn't really talk about what I like to do outside of work. So just a few things to get to know me better.
Yeah,
I'm a Huntington Beach gal. I love outdoor activities, mainly because I grew up back east in the cold. So I now like biking and running outside and hiking. In fact, my husband and I just hiked the most active volcano in Guatemala about a month ago. It's called Pacaya. Very fun, but also very challenging. I golf just about every weekend, and I just got a new puppy. So super excited about that.
Oh, that's terrific. Yeah, I was Jeff, I was just telling Kristi offline that I took the family to Legoland for the weekend. We came back early because the kids were worried about their new kittens. They hadn't been away from their new kittens. So Kristi's got a new puppy. My kids got new kittens. New pets are always a a fun challenge to have in the house. Well, Kristi, you mentioned being from the cold back east in Philadelphia. What brought you out here, and what brought you into labor and employment? Were you in labor and employment when you were practicing in Philadelphia as well?
So I wasn't. So I actually started off more as a general practitioner, and I handled, a wide array of legal issues. But I remember getting my first employment law case, and I was representing the employer. And I remember opposing counsel really trying to make my client look like the big bad company. Right. And I just kept thinking, look, this employer is doing the best that they can, given the many employment laws that they have to navigate. And now that I'm in California, especially the many employment laws here. And I just remember thinking, they're trying to do everything right for their clients, or their employees. I'm sorry. Maybe they just need a little bit of help or guidance in doing so. And the case really appealed to me, and I decided to start specializing in employment law.
Yeah. And are your cases usually in state court or federal court or arbitration? I know there's a lot of employment matters that go to arbitration.
Yeah, so I have a mix. Most of mine are in state court or arbitration. And the reason we're seeing so many in arbitration is because employers nowadays have valid binding arbitration agreements with their employees. So we often move to compel the matter to arbitration. The cases that I have that have stayed in state court, the named plaintiff hasn't signed an arbitration agreement. So we're sort of stuck there. And then I do have a handful right now that are in federal court. And those typically started off in state court as class actions. But the same type of thing, the named plaintiff, the representative, did not sign an arbitration agreement. There's no class action waiver. And so unfortunately, the class action remains. We can't go to arbitration. So what do we typically do? We try to remove the case to federal court under something called the Class Action Fairness Act. But a lot of my cases are in arbitration right now.
So what stands out in your mind? I know that as attorneys, we and a lot of our listeners know some of the basic differences between state and federal court and arbitration. What are some things that stand out in your mind as distinct advantages of one forum over another, in particular for your area of practice in labor and employment?
Yeah, so let me talk a little bit about arbitration, since so many of my cases are in that venue. I think any venue has pros and cons, Tim, but arbitration, I mean, we tend to like arbitration for our clients because there's limited discovery involved. Okay, it usually moves along on a faster track than a case that's in court. There's usually some aspect of confidentiality to the proceeding, which the company or the employer likes. And then the big thing, the most important thing, is that the case is not being tried by a jury, right? We have a neutral, or there's supposed to be a neutral arbitrator hearing the case. So those are the pros, I'm sorry. And then, in terms of cons, disadvantages, I would say for employers in California anyway, employers do have to pay the arbitrator's fee. And sometimes that can get a little high. But, pros compared to the cons, I think the pros outweigh the cons for arbitration.
Well, and the biggest con, you'd have to say, is the lack of an appellate remedy and a lack of a role for appellate counsel in any arbitration, right?
Right.
Yeah, very, very limited in terms of appellate remedies when you're in arbitration. It's not good for our business, Jeff.
Yeah, I do have to ask, while we're on the subject, do you ever I see sometimes the AAA or JAMS offers a limited arbitration appellate remedy where you have an appeal from the arbitration within the JAMS or AAA structure. Have you ever participated in one of those or no?
I have not. No, I haven't.
Okay. Yeah, interesting.
All right, Kristi, let me ask you this. What do you think that clients or opposing counsel would say is unique about your legal practice? Now, you're a labor and employment attorney representing employers. What do you think makes you unique about the cases that you take on or the way that you practice?
Mm-hmm. So I think my clients would say my ability to offer full service in all things employment law. Right. So some employment attorneys only do litigation. Some employment attorneys only do workplace investigations. Others only do counseling. I do it all. So I not only litigate, but I'm on the phone with my clients, sometimes on a daily basis, advising them, counseling them on their policies, practices, procedures, daily workplace issues that they're dealing with, in order to try to avoid lawsuits. And then on top of that, I go out and perform trainings for the managers, the supervisors, and the employees at these various companies, at our clients. So I would say, yeah, my ability to really offer full service.
Yeah, that seems somewhat rare and difficult to do, to be able to offer that soup to nuts, doing the advisory services and counseling services pre-litigation in hopes that the employer will never have to be involved in litigation, but with the realization that probably sooner or later you will face a lawsuit from a former attorney or former or current employee. Sooner
or later in California, it's bound to happen.
Right. Kristi, do you have any good war stories or litigation stories that you'd like to share? Litigation mistakes, maybe, that you've seen someone make that are just indelible, that you'll never forget, and that you'll always avoid making in your practice?
Yeah, I'm sure we've all seen just a ton of stuff, but one thing that comes to mind, and it seems pretty simple and straightforward, but make sure you're reviewing the items you turn over in litigation or to opposing counsel before you turn them over. I had a case once. I was representing the employer, And the employee had taken, or my client thought they had taken a lot of confidential information, customer lists, stuff like that. And then they went to work for another employer. And the thought was that they were using our client's confidential information at their new employer. So I obviously subpoenaed the records from that other employer. And the other employer was represented, by the way. But when I got the records in, I mean, I just asked myself, I'm like, did the other lawyer really even look at this stuff? Because there was no fight put up, the stuff was just sort of handed over, and it was very, very helpful to me. So I think the lesson is just always review things you're turning over in litigation, even if it's just to be prepared and see what's coming down the pipeline.
Yeah, you don't want the first time you see a document you produced to be in a filing by your opponent.
Absolutely not.
Okay. Last question before we dive into your article about the ethical pitfalls in referring clients. Kristi, what is your favorite part of your practice? So you do it all in labor and employment, from consulting and advisory services to the litigation itself. What do you like the best?
I like that it never gets boring. And I say that because the California employment laws, the regulations, the rules, they're constantly changing, guys. I mean, every year I'm having to get up to speed on new employment laws that have been passed. I'm having to discuss them with my clients, and we're having to determine how to tackle all of these new requirements. Okay, the best example and the most recent example I think that I can give are all of the COVID-19 related laws and regulations. At one point, it seemed like OSHA was changing the rules as they apply to employers on a monthly basis. And so you really got to be on top of that stuff. You have to know that stuff. So there's never a dull moment when it comes to California employment law. Okay,
Kristi, let's talk about the article that you published in the Orange County Lawyer magazine back in August of 2022. It's titled "Avoiding Pitfalls When Making a Referral to Another Lawyer." So let's talk about some of the ways that an attorney can avoid incurring liability in the process of making referrals. And the first one that jumped out at me is frankly one that I had not given enough thought to, is the potential liability for making a negligent referral. That was one trap I was aware of that I wanted to learn more. Another trap I wanted to learn more about was about referral fees, which is another one that you talk about. But negligent referrals, Kristi. So let's say you referred a client to another attorney and that attorney screwed up. Can you really, as the referring attorney, be made liable for making a negligent referral?
So the short answer there is yes, you can. But I think there's a distinction to be made here between legal malpractice claims on the one hand, okay, and general negligence claims on the other hand. For a legal malpractice claim, the person needs to be your client, okay? And I'm sure we'll talk about this in a little bit, how to avoid forming an attorney-client relationship with a prospective client. But for a legal malpractice claim, the person needs to be your client. When you're acting, and we all know this, when you're acting as somebody's lawyer, you have a fiduciary duty to that person, okay? And it's probably a heightened standard of care that you owe them. I would be willing to bet that if you were sued for legal malpractice, somebody could probably persuade a judge to include a heightened standard of care language in the jury instruction, okay? But that's legal malpractice. Switching gears to general negligence, that's a much lesser standard. I mean, let's think about those elements from law school, right? There's just 4 of them. You need duty, breach, causation, and damages, okay? Really, anyone can be sued for general negligence. You don't have to have just your client sue you for negligence. It can be a prospective client who can sue you for general negligence. And so the question becomes, how do we avoid a lawsuit that's related to a negligent referral. And there are a few things that you can do to keep in mind. So when you are talking with a prospective client and you're referring them, number one, you want to give them the names of several attorneys. Okay, don't just give them the name of one lawyer. Provide them with several names. Number two, you want to say that you can't vouch for these other attorneys. Okay, this is not an endorsement by you. Yes, you're providing them with some names, but you're not vouching for them. Number three, suggests that the person actually conduct their own research, including interviewing these other attorneys to see if they're going to be appropriate for their case. Okay, that's number three. And then the last one, and this is especially important if you have a prospective client who is going down the path of thinking that they are your client, put something in writing.
Yeah.
Okay. And you can obviously word it in a diplomatic way, but say something to the effect of, I'm not your attorney. I mean, maybe you even send out like a non-engagement letter saying something to the effect of, as you know, we've had to decline representation. Okay, there's nothing better than having that in writing. All right. And one other thing I do want to mention on this, and I think it's worth mentioning, there is one exception to the idea that only your client can sue you for legal malpractice. And that exception comes into play when we're dealing with intended beneficiaries. And I think this is worth mentioning, okay? And the best example, the number one example I can think of there involves beneficiaries to a trust. So let's say that you are a trust attorney and you're preparing a trust and you make some sort of mistake, okay? An error, you miss a rule, I don't know what it is, but you mess up, all right? And the trustor ends up dying. Well, the trustor obviously can't sue you. Maybe his or her estate can, but he or she can't. But think about it. I mean, who's really going to be damaged in that situation? It's the beneficiaries. And you may say, well, I prepared this trust and these beneficiaries were not even born yet. There's no way they can sue me. No, if there are express or intended beneficiaries, they can sue for legal malpractice. And the other interesting rub there is that not only can trust work really open the door or expand the class of people who can sue you for legal malpractice, but there's also a statute of limitations issue. So the statute of limitations on legal malpractice claims in California is 1 year. And so again, you might be thinking, great, awesome, that's going to come and go. I'm not going to get sued. But the thing is, the statute of limitations does not start to run until an actual injury occurs. So that's usually some specific event. Usually it's the wealthy trustor dying, right? So you can prepare this trust and then 20 years later, you're sued. I mean, for legal malpractice, it can happen, okay? But yeah, setting that aside, prospective client, how to avoid the negligent referral, the names of more than one attorney, say you can't vouch for them, tell them to conduct their own research, and really put something in writing. That's big.
Those are three really good tips. Let me ask you to back up 1 second. When we're talking about the difference between suing someone for malpractice and the difference between a general negligence case and the lower standard of care or the lower burden of proof, in a legal malpractice case, you always have to prove the case within a case, that but for the malpractice, you would have won the underlying case. It's usually hard to prove that causation. Is there no equivalent requirement for negligent referral cases that you don't have to prove that but for the negligent referral, you would have won the prior case, et cetera?
That's a great question, Jeff. I'm not aware of that. No.
Makes it easy. Hey,
you wouldn't have to prove that. If you wouldn't have referred me to this derelict, I would have found this top-notch attorney who would have won my case for me.
Right.
And then the other question I had is, and don't provide me anything that's super secret or anything, but do larger firms like Shepherd Mullen have policies regarding if a prospective client calls us and asks us for a referral, do not give a referral, or here's what you do if you're going to give a referral? Do they have big policies in their procedures?
Well, I mean, I'm not aware of something formal in writing at large firm. I mean, maybe some large firms have them, but like, I think the biggest thing is, well, there's going to be a client relations issue possibly, right? Because if a prospective client calls you and they want a referral, and it turns out that maybe your firm already represents someone adverse to them. I mean, my understanding is you can make the referral for the prospective client. I'm not aware of California law saying you can't. In fact, there are cases in New York and District of Columbia that say you can make the referral. But from a client relations standpoint, are you going to want the other client at the firm or the partner handling their case to be calling you up and saying, why did you refer this person out to somebody who's now suing my client, right?
Yeah.
So it's just, you gotta make that decision, I think, on a case-by-case basis.
Is there any room for avoiding liability? So let's go back to your 3 tips to avoid this pitfall of liability for negligent referrals. You suggested give multiple names rather than just giving the prospective client just one name, which could lend the suggestion that this is your go-to. This is the person who's going to serve you best. Give multiple names. Don't vouch for any one of them. And instruct the potential client to do their own research and send out a non-engagement letter. Is there any way to avoid or limit liability by if it's your legal assistant giving out the name rather than the attorney personally?
So that's a great question too. I think a lot of firms for the intake process, they do have a paralegal or some sort of intake specialist handling this, right? Not the attorney. And so, and the paralegal or intake specialist may be great. They're probably well trained. They're probably better at doing the onboarding than the attorney. But what I would think of putting in place is some sort of policy that says the onboarding process is not complete, or the intake process is not complete until W, X, Y, Z have occurred, right? That way the intake specialists and the paralegals know really what needs to be done. And then maybe you do have a battery or a list of people, like if you do personal injury, you can't take it. You have a list of people that you refer to, and the paralegal or the intake specialist can give the person that. So I think that would be helpful.
Yeah. So if you're just kind of sending out, instead of the attorney personally saying, you should really talk to Kristi Thomas about this, you could have your legal secretary saying, here's a list of some of the attorneys that that we know of who practice in labor and employment law: Kristi Thomas, Jane Doe, and John Smith. Then that suggests that this is just a standard list. No one of them is being vouched for or referred as a specialist in your particular case.
I think that would be helpful. Yeah.
Yeah, and I think Jeff, thinking back to our episodes about using legal tech, I'm getting some ideas for some text expanders to put in emails. I'm not your client. I'm not your attorney. None of this is legal advice, and I don't vouch for any of these attorneys that whose names I'm giving you.
Yeah.
Okay, Kristi, let's go back to your something else you said in your article: avoiding pitfalls when making a referral to another lawyer in Orange County Lawyer Magazine. You said something in that article I wanted to ask you about because it was just a great line that stood out to me. When making a referral, obviously you want to refer. You want to be able to refer to someone who's going to be a winner. We talked about you shouldn't vouch for that person. Don't make any guarantees or representations, but you want to have a good feeling about this person, obviously, if you're going to refer a potential client to them. You cautioned that that a long list of victories on this referees, the attorney that you're referring to, you might look on their website and it'll show a long list of victories, but that doesn't always mean that the attorney is any good, you point out, because you say in your article that, quote, someone with a long history of well-publicized victories might not promptly return client phone calls, or may be abrupt or even rude when doing so, end quote. And then here's the line that stood out to me. You say, quote, they may be a lion in the courtroom, but a dud in the library, end quote. I wanted to ask you what you meant by that. A lion in the courtroom, but a dud in the library.
Yeah, I'm glad you guys asked this question so we could flush this out a little bit. Okay, so what do I mean? A lion in the courtroom, a dud in the library. What I mean is, yes, we are all attorneys. right? But we're also all human. So some of us are very good or excel in one area, and maybe we don't excel as much in another area. So maybe the best way to think about this, maybe we've seen this with some of our colleagues. This is the way to describe it. So you have one colleague who is very good at presenting, but they're not as good at negotiating. Or you have one colleague who's very good at research, but they're not as good at writing. Okay. I'm not saying that they're a bad attorney at all. I'm not saying that. I'm just saying they tend to excel in one area over another. So when you're referring someone, the prospective client, you don't want to say to them, look, I have the best attorney for you. This is the best. Okay. What does best attorney even mean? How is that defined? Okay. Instead, what you should be asking yourself, what am I looking for in the person I'm referring to in the context of this issue or case? Because maybe you don't need the lion in the courtroom. Maybe this looks like it's going to be a small case. It's going to resolve fairly quickly. You don't need the lion. Or maybe you see that this might be a super high profile case, very contentious. It's going to go to trial, and you know a stellar trial attorney to refer them to, but you also know that that attorney sends out very, very heavy bills. Are the heavy bills going to matter in that situation? Maybe not. And then I'll just give you a third example. Let's say you have a prospective client who has called you 10 times within 24 hours, despite you talking to them each time and saying, I'm gathering some names for you to refer you to. And you have attorneys in mind, but you know that two of those attorneys are very, very bad at promptly returning client calls. Maybe this is not the person to refer to them. Okay. So whenever you're referring, you just want to think about, what am I looking for in the person I'm referring to in the context of this issue or case?
Right.
Yeah. I was just say interesting, also the cases, sometimes you have somebody who's a lion yesterday, but today and tomorrow might not be a lion. I wonder if Tom Gerard gotten any referrals in the waning years of his practice, whether any of the referring lawyers there are facing negligent referral lawsuits.
Oh my goodness.
Mm-hmm. Yeah.
Sorry, Tim, go ahead.
Well, no, that's right. You have to find the right attorney for every occasion. But it's interesting how these issues kind of bookend that. It's important to find the attorney who has the right niche, not just any old labor and employment lawyer. You might need, you might be ready to go to trial next week, and you need a last minute trial attorney who only does trials, and they relish getting the file the night before the trial and working it up and going in there and cross-examining witnesses. And then you have the other needs are just, I want to avoid lawsuits. I want to be best positioned to defend myself in a lawsuit if I get them. So you want to be able to know the person you're referring to, the potential client, so that you're giving them the best referral. But again, back to your first advice, you don't want to vouch for anybody and say that this is really the person who's going to serve you best for your situation, because again, you don't want to you want to limit your exposure to liability for negligent referrals if that attorney doesn't wind up serving the potential client well.
Mm-hmm. Mm-hmm.
Okay. Tell us about referring an existing client to another attorney. We've been kind of talking about, you get a phone call from somebody and you're turning down the representation, or it's not your practice area and you're referring it out to someone else that you may know because you want to help other colleagues maybe, or you just happen to know someone that may be able to help the potential client. But what about are there different considerations, Kristi, for existing clients? Say that you have an ongoing relationship with the client, they have a need for something that you don't provide, and you're going to refer them outside of yourself or your law firm. Do you have what duties do you have to your existing client when you refer them out to another attorney? Do you have to research the attorney? How much do you have to know about the other attorney before you refer them to your existing client?
I think it's a great question to ask your existing client how much they want you to do for them. Okay, so you may start off by saying, or you may initially say to them, hey, Do you just want my off the cuff thoughts on attorneys to refer you to? And they'll probably say, yes, stop there. Or you say, do you want me to conduct more research on these attorneys? Okay. Some attorneys will even go out, and I can share this with you. Attorneys at my firm have gone out of state to places where we don't have offices to sit down and meet with attorneys at other firms to see if they would be a good fit for existing clients. And they've actually charged the existing clients their full rates in order to do that. So I think it depends on what the client wants. I also would probably bet that because it's an existing client, there is probably a heightened duty there when it comes to referrals. I mean, look, this is your client. Maybe whether they're a high-paying client or not, they're going to expect you to refer them to attorneys who are well-equipped to handle these cases or these situations. But have an open line of communication with them and see how they want you to proceed.
Right. Yeah, and I guess that's a good conversation to have before you start billing your client for doing that research, if that's not something that the client envisioned.
Absolutely.
Okay, let's review some basics that sometimes some of us might forget about. Avoiding the formation of an attorney-client relationship during the referral process. Now, I'll volunteer that I could use a refresher on this. So when I pick up the phone with a potential new client for the first time, exactly when does the attorney-client relationship get formed, and what steps can I take to avoid forming that relationship before I'm ready for it?
Yeah, so this is a tough one. So look, in a perfect world, you should tell the prospective client not to divulge confidential information to you, and only to give you enough of information that you need to run a conflict search, okay? Because what's the danger if the prospective client gives you too much information? Well, it's twofold, okay? So number one, let's say that you've had the call with a prospective client and you're running a conflict search, and it comes up during the conflict search that another attorney at your firm is actually representing the party that's adverse to this prospective client. And then on top of that, I just got a ton of information from this prospective client during my phone call with them. All right, the risk there is that the partner at your firm already representing the adverse party could be conflicted out. And I can tell you, he or she is not going to be happy about that. Okay, so that's number one. The second thing is that you form an attorney-client relationship with the prospective client. So let me give you an example here to try to illustrate this. Let's say you're at a dinner party, okay, and everyone's chatting, small talk, and somebody says, "Can you believe I got sued the other day?" And you say, "Oh, really? Well, I'm an attorney. What kind of case is it? What'd you get sued for?" And they say a car accident. And you two get to talking throughout the evening. And the dinner party ends. You don't hear from this person until 28 days later. You get a phone call from her saying, "Hey, are we going to respond to this complaint? It seems like we should probably do something here. What's the holdup?" Right? So that person obviously thinks that you are her attorney. Now, the standard for forming an attorney-client relationship, or whether one has been formed, is what would a reasonable person in the shoes of the prospective client had thought? What would a reasonable person in the shoes of the prospective client had thought? So the relationship is really in the eye of the beholder, and that beholder here is the prospective client, okay? So how do we avoid forming the attorney-client relationship during your phone call? I mean, the biggest thing is don't onboard confidential information. If you're just kicking the tires around and not divulging confidential information, there's no relationship. But in the real world, that's really, really tough, because maybe you're talking to this person for the first time You haven't talked with them before. You're trying to obviously make a good impression because they could be a potential client. They want to get things off their chest and tell their story, and you don't really know where to draw the line. So is it that they're just giving you their name, their adversary's name, and the type of case? Oh, it's an employment law case, sexual harassment claim. Or are they really getting into the details with you? Well, in December, we conducted an investigation at the workplace. We interviewed these people. We determined maybe employee X did harass employee Y. Oh, and by the way, we don't have a policy on this. We need your help in drafting a policy. Okay. It's really when they start getting into the details. Again, it's hard to know when to draw the line, but I would just tell them, guys, right up front in your conversation, don't divulge confidential information to me. And then the second big thing is try not to do or say anything that would make them reasonably believe a relationship has been formed. Tell them you're not their attorney. The biggest thing is communicating that there is no relationship. And I know I had mentioned earlier about putting something in writing. Do it here. I mean, send them an email. Hi, so-and-so. Great speaking with you today. We're running a conflict search, but please continue not to divulge confidential information to me. An attorney-client relationship has not yet been formed, or it has not been formed. Something like that. Does that make sense?
Yeah, I wonder if I can ask you just a couple of follow-ups about that, just because confidential information, I'm going to put that in quotation marks. You and I, as attorneys, have an idea of what that means. The potential client might not always know what that means. And then the same thing about, or similar problem with saying that I'm not your attorney. If you say that at the end, well, we know that the attorney-client relationship is formed is kind of a subjective standard, whether the client believes that an attorney-client relationship is formed. So sometimes we announce that pablum that oh, I'm not your attorney, I'm not your attorney, I'm not your attorney. But if the client believes that I'm but I told you all this stuff, and I told you I'm desperate for an attorney, and you talked to me, and anyway, I wonder if it might be a best practice during a phone call, say with a potential client, for the attorney to control the conversation and make sure that the attorney is asking questions, and make sure that it's kind of like conducting a deposition. Don't let the potential client go off on a narrative explanation, because you're going to wind up getting getting all the inside information about the case.
Yeah, I completely agree with that. Look, they want to vent, right? They want somebody to tell their story to. So what it might make sense to do, and this goes along with the intake policy that I had referenced before, but maybe you have at the firm some sort of policy or questions that are to be asked of the prospective client, just keeping it very basic. What is your name? Okay, what company do you work at? What's the name of the party suing you? Give us that information. What type of case is it? What are the claims in the complaint? Something like that, and leave it very basic. I completely agree.
It's probably a best practice. I mean, I think we attorneys figure that we like to have our assistants and paralegals take down the initial intake information, because obviously it saves our time. But I think that's probably also a good firewall to make sure that we're not conflicting ourselves out, because that intake person knows just to ask these types of questions, and the potential client probably knows don't bother giving a narrative explanation of the case, because this is only a person who's filling in blanks on an intake form.
Mm-hmm. Yeah, and I mean, sometimes there's a lot to be done before the intake process is actually complete, right? And they become your clients. So some firms, I know, check the person's credit worthiness. Some firms do a background check. You obviously need an engagement letter signed. Maybe you need a retainer agreement, right? So it's best to probably indicate, look, until we get all of this stuff ironed out, because there may be quite a few things, there's no attorney-client relationship yet. Yeah.
The trouble for me personally is I have an exception for, I don't I don't make referrals from other colleagues go through my intake person. I will usually take their call directly, and now I'm going to be more wary that I could get into trouble there because suddenly they've got an attorney on the phone and they want to vent. They want to divulge all the confidential information about their case because they might think that, hey, a trusted person already vouched for you, so you're my guy. I'm gonna give it all to you right now. So you have to be very, very defensive in your initial phone call with the potential client.
Yes.
I wanted to ask you something else. This is kind of off the cuff, but it's specific to Jeff and my practice as appellate attorneys. A lot of the time, we will consult directly with the trial attorney, and I wonder if that sparks any ideas for you about potential ethical issues or opening up liability for to the client. Sometimes in my relationships, I might not even speak directly with the client. I'm just more or less a consultant for the trial attorney. But my understanding is that I'm still an attorney, and the ultimate client is still the client, even if I am relating indirectly with the client through the trial attorney. I wonder if that raises any potential issues there. If I'm taking direction from the trial attorney, do I have at what point do I have to go to the client for something? If let's say that I detect a potential malpractice issue, for example, that could get very sticky, I imagine.
Yeah. Oh my gosh. Yeah, that's a good question, and definitely a tough area, and it can get sticky. So I mean, thinking just offhand right now for appellate lawyers in particular, I don't know of issues that could come up offhand. If I think of any, I will reach out to you guys.
Kristi,
yeah,
I know most of your work's in arbitration, but
right.
if you take nothing away from this podcast, take this away. Always ask for a statement of decision, and always bring a court reporter to a big hearing. And if you don't do those things, or if you're an appellate lawyer and you discover the trial lawyer has not done those things, that's an uncomfortable conversation that an appellate lawyer has to have with the client about those topics.
That's a great point. Yeah.
That's right. Okay, let's talk about conflict referrals. So this happens from time to time for litigation and trial attorneys. So in the instance where you have two clients and then suddenly a conflict arises and one or both of those clients will now need a new attorney. So Kristi, can I refer those clients, that conflict client out without tainting the new attorney with the conflict? So if I have, two clients and now one of them has a conflict, I want to keep one and send the other out. I guess I have to be careful not, again, back to your first tip, not to vouch for the other attorney. I give them multiple options, but to the extent that I have a pre-existing relationship with that other attorney as a colleague, do I have to worry about having tainted that colleague with my conflict?
Yeah, so this is a very difficult question to answer, and I'm going to try my best to answer it by talking about a few different scenarios here. Okay, so let's talk about where I usually see this issue arise or come up. It's in the context of joint representation. So talking about my bread and butter for a moment, which is employment law. Let's say that I represent a company, the employer, and I'm also representing one of their employees. Okay, one of their employees got individually sued, so I'm representing both of them. And maybe the company we call them the alpha client, so they're the ones paying the bill, and the employee is the beta client, they're not paying the bill, all right? But something happens during the representation. So I don't know, the employee ends up stealing stuff from the company, he has to be terminated, and so there's a conflict issue. You should already have in place a joint representation letter or agreement discussing the pros and cons of joint representation, okay? And you should really have language in that agreement which allows you to decide which client you're going to continue on with, that allows you to drop a client, and you want both clients to be acknowledging that they understand that, okay? Now, when you need to drop, for example, the employee client, the new attorney, and again, this is in the context of joint representation, the new attorney they're going to get a copy of the file, because with joint representation, you can't keep communications from joint clients. So they're going to get the copy of the file. But yeah, to your question, can you refer that employee client out to the new attorney? And so let me sort of present another scenario here, and maybe it'll help us answer this. So let's say you're not in the situation of joint representation. Your firm just represents two clients, two separate matters, okay? And the conflict was not picked up on at the outset, and you just now determine the conflict. So can you refer one or both of them out? I think that's the conundrum, and I think it's going to be problematic there, because on the one hand, you have, like we talked about earlier, you have an existing client who wants you, of course, to refer them to well-equipped counsel to handle their case. But on the other hand, you're essentially picking their adversary, right? The other client's attorney.
Right.
And I think that's gonna pose a problem. Now, if you do decide to refer out, you have to be very, very careful about not divulging confidential information you have on the other client. And let me just throw a third scenario out there, because we see this one a lot too. Let's say that your firm or you want to serve it's just a records subpoena on a firm client. In California, anyway, that's going to be considered direct adversity. Serving a record subpoena on a firm client is direct adversity. So what do? You probably call up the relationship partner at the firm. So the partner who represents the client you want to serve the subpoena on, you tell them the situation, and then he calls up his client. He says, look, I have a colleague. They're just serving a record subpoena on you. Is that okay? And most of the time they'll say okay. But what if they say, nope, that's not okay? So what do? You're going to have to call up outside counsel. You're going to say, look, I need conflicts counsel. I need you to take this very small portion of this case. It's just serving a subpoena. Can you do that for me? And again, the question is, what can you tell them? How much can you share with them? You cannot divulge confidential information concerning the other client. I mean, you don't want to give them the keys to the kingdom, because they could then be conflicted out, if that makes sense. And it's sort of like, remember that crazy fruit of the poisonous tree doctrine from law school? It's sort of like that. You have confidential information, you're conflicted out. Okay, here's the new attorney. Don't pass the confidential information on to them, or they're going to be conflicted out as well. So it's really a hairy issue, guys. It's tough.
Yeah. So I guess that means, don't have in-depth conversations with the potential new counsel. Certainly don't divulge any confidential information. But I guess just giving a name and phone number to the soon-to-be former client would probably not get you into too much trouble. Is that right?
Probably not. Yeah.
Yeah, I don't even know if you could whisper to your successor, to this new lawyer, that there's a conflict, the existence of a conflict that might plant ideas in their head. I don't know.
Yeah, it may. So that's a really difficult one.
That is hard, because when when you're looking for a new attorney, that new attorney is going to want to know, what's the deal here? How come you're leaving the representation? Because when you're not the first attorney on a case, that's that raises a red flag in the attorney's mind, that you don't like to be the second, third, fourth in line, because that suggests that there's could be a problem with taking on the representation. So they want to know that it's I don't think there's any problem letting them know that there's a conflict, and that should trigger another warning flag that, okay, I should be careful in eliciting information from the former counsel that could disqualify me, that could imbue me with the same conflict that that former counsel has. So these are important questions to ask, because again, it's a conversation that is attractive to have for the new counsel, because look, I can get the scoop. I don't have to go through and investigate the file. I can just kind of get the skinny on what this case is about from former counsel. But be very careful there. You could conflict yourself out.
Yeah, be very cautious.
Okay. All right. The last question I wanted to ask you, Kristi, about your article, avoiding pitfalls when making a referral to another lawyer. And this is about the question of referral fees. Now, there are a lot of attorneys who swear by referral fees, love to give and to get referral fees, and other attorneys who just won't touch them, won't ask for them, won't take them. What should attorneys know about giving and retaking referral fees?
Yeah, so my response here, I think, is pretty short and to the point. And it's, if you have a referral fee agreement, it will be void unless you have client consent. Okay, the referral fee agreement needs to have client consent. So, and I like to give this example. Let's say that you have a huge wrongful death case that you're considering referring out to somebody who specializes in these types of cases. And you and that attorney agree that you're going to get a 10% referral fee. Okay. And the case ends up going to trial, and the plaintiff does much better than anyone had expected. In fact, they recover $50 million at trial. And the attorney that you referred them to decides, no, you know what? I'm not going to give him his 10% referral fee now, okay? And you sue for that referral fee. The number one way that you're not going to get that referral fee is lack of client consent. A lot of attorneys agree on referral fees in the dark without the client knowing about it. Can't do that. It needs to be in writing with their consent. And I think, just to tie into our other issue on negligent referrals, I think referral fees could also, in a way, affect a negligent referral case. And what I mean there is, let's say that you have two really good attorneys in mind that you want to refer a case to, but they don't pay a referral fee. You come across somebody else who pays a referral fee, and you give them the case, okay? And that attorney loses, and you're sued for making a negligent referral. The optics there, guys, are going to look very bad that you passed up two really good attorneys because they didn't pay a referral fee and went with the other one who did pay them or pay you the referral fee. I mean, what if you have a trail of emails, a ton of them, just showing you shopping around for the highest referral fee? It's not going to look good. It's not going to look good. And then just, one more point on that. I think that the rule that you need client consent for referral fees really illustrates something here about the rules of professional conduct. The rules of professional conduct are enforced by the state bar, okay? You can't have a cause of action for damages for violating a rule of professional conduct. The state bar enforces them. But I will tell you, courts look at them and they borrow from them. So if you are in court on this referral fee issue and you say to the judge, wait, Your Honor, we had a binding contract here, myself and this other attorney, where he agreed to pay me 10% in referral fees. You have to enforce this. The court can say, no, I'm not going to enforce it because you don't have client consent there.
Yeah. Well, and one thing that occurred to me while you were explaining about how referral fees can play into liability for negligent referrals was back to your rule again about providing multiple potential referrals, not just one attorney's name, but multiple names, and especially if one or more of those names that you're giving gives you back referral fees. So if you're recommending somebody who gives you a referral fee, make damn sure that you are also giving the name of one or more other attorneys who don't have a referral fee relationship with you.
Absolutely, absolutely.
And if you are the referring attorney, do you need to disclose to the potential client, if you're giving the name of another attorney who gives you referral fees, do you need to disclose that to the attorney, or can you just leave that for the referring or the other attorney you're referring to count on them to disclose that to the client?
So, but I believe it needs to be disclosed in the agreement that the client needs to consent to. So there's a rule on professional conduct on this, and I'm blanking on the exact rule number. There are so many, but it basically says it needs to be in writing. You need client consent. The actual terms of the referral fee agreement need to be in writing, who's involved, who's going to get what. And then the fee that the client is paying cannot be increased solely because you're dividing fees, right? So I'll just throw things. I mean, if you usually charge $100, just throwing this out there, but now it's $110 because you're going to give a $10 referral fee. You can't up the fees just because you're going to be dividing them, if that makes sense.
Yeah.
Okay,
well, Kristi Thomas, thank you so much for coming on and talking with us about your article, Avoiding Pitfalls When Making a Referral to Another Lawyer. Just as we close here, were there any advice that we didn't cover that you want to cover with our audience, or any parting remarks or advice for our audience? Not legal advice. You are not their attorney, but just any parting words.
We didn't establish that Kristi and her firm are lawyers of record for all of our listeners. We didn't establish that during the podcast.
No, I mean, this was great, guys. Thank you so much. I mean, I guess the only other question that I have had before and that others might have is, will the insurance, like the malpractice policy, cover a negligent referral? And there may be people wanting to know that. And I think the easiest answer there is just take a look at your policy and read the exclusions, and ask yourself, if I make a referral, is it going to be covered under the insuring agreement? Some of them, guys, are very, very broad, these agreements, and they cover any act, error, omission. They may even cover paralegals, and we know that paralegals aren't supposed to be practicing law, but they may even cover them. And some agreements are more narrow. They could just cover, professional legal services rendered. So you really need to take a look at the policy and the exclusions there.
I wonder to the extent a plaintiff is trying to avoid the high burdens of proving a legal malpractice case, and they want the easy standard of a mere negligence case, if such a claim for negligent referral might be covered by just a general commercial liability policy, if not your legal malpractice case. It's negligence, just like a trip and fall.
Yeah, it possibly could.
Interesting.
Yeah, that was a big light bulb moment for me, Kristi, when you mentioned about this is just general negligence rules, not necessarily professional malpractice, but general negligence. That's I think a lot of attorneys in our audience should stand up and take note of that. That is a little scary, but as Jeff pointed out, there may be maybe an additional way to address that, because it is just general, just like a slip and fall.
Mm-hmm. Mm-hmm.
Okay, well, that's going to wrap up this episode. Again, we wanted to thank our sponsor, Casetext, for sponsoring the podcast. And each week we include links to the cases we discuss using Casetext. Listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
If you have suggestions for future episodes, go ahead and please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right, thanks. See you next time. And nothing in this podcast establishes an attorney-client relationship. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.